it's time to shift gears. I think I've beat the crap out of the dead horse long enough about status and what it means to correct your status. And so now we're going to return to a book I've read, gosh, I can't even mention how many times, maybe a half a dozen times now. And every time I read it, I pull something great out of it. And so naturally, I'm going to revisit it. Excuse me. It is said that life and liberty stand essentially upon the same ground, life being useless without liberty. Thus, the law allows people to protect liberty as they would their life. Any person who wants to protect and preserve liberty and to check the arbitrary acts of government will find this material critically important towards such ends. When one is unlawfully deprived of his liberty, he has suffered a false imprisonment, whether it be by arrest, imprisonment, or improper procedure. Throughout history, the most common violation committed by governments against the rights of the citizens is that of arbitrary and summary arrest. Such measures have long been the earmarks of a corrupt and despotic government. To safeguard liberty, the common law has for over 1,000 years established certain rules and procedures that must be followed before one can be deprived of their liberty by way of arrest or imprisonment. These rules and procedures are part of due process of law, and any officer or person that does not follow them can be sued for false imprisonment. This material details the limitations and requirements of government officers in making arrests, issuing warrants, imprisoning persons, and enforcing the different types of laws, misdemeanors, breaches of the peace, and felonies. The fundamental law on these matters will strike at the base of the corrupt police state system that is so prevalent today. It is often said that the liberty of the citizen is too sacred to be interfered with without establishing sanctions by which the law guards it. Individual liberty is being violated hundreds of times every day because the people have forgotten the law which protects that liberty. So, we'll get started here. Oh, come on. This is a treatise on arrest and false imprisonment by Charles A. Wiseman. Feel free to go look it up and read it for yourself. It's kind of hard to grab off the internet nowadays. And we're going to get into it because once you understand your status, now you can effectively bring suit and protect it. This book is about liberty. It is about the lawful and unlawful means by which government acts in depriving an individual of his liberty. History teaches that deprivation of liberty is more often arbitrary and unlawful than it is otherwise. At least this is always the tendency of those who hold executive power. Daniel Webster once stated this problem in these words: "The contest for ages has been to rescue liberty from the grasp of an executive power. Liberty is taken away or deprived most commonly by arrest and imprisonment. The practice of easy arrest and secret imprisonment has always been an earmark of despotic executive power. To compound this problem, we have the legislative mills which turn out thousands of new laws every year. The passion of modern legislators to regulate every facet of the most intimate concerns of everyday life is notorious. This would be oppressive enough if administered under the requirements of a warrant or summons, but it becomes doubly intolerable if every zealous officer is authorized to arrest on sight every person whom he detects breaking one of these laws. No one can be safe to leave their home or to travel about for fear of being subject to thousands of unknown laws in which he could be instantly arrested for transgressing." One law review writer states the problem as follows: "People no longer live their whole lives in the village in which they were born. They pass freely from place to place, and in transit go through innumerable towns and villages. The risk of being arrested on site because one's conduct contravenes some regulation which the wisdom of the local salons deem necessary is appalling to any thinking person. It would be impossible to know at what moment one might be amendable to arrest. A revolution in England and the revolution in the American colonies are said by high authorities to have been largely influenced by promiscuous seizure and search of persons and property. The history of our ancestors over the centuries teaches that the people cannot be free where the executive power can arbitrarily arrest or imprison citizens or ransack at will the properties of the people. The executive power is limited and guided by the law of the land or due process of law. If it was restricted upon the King of England, it must be so for every petty officer today. In many of the treaties on the laws pertaining to the rights of citizens and in many of the older and better court cases, we find the declaration. The law is very jealous of the liberty of the citizens. What law is it that so regards liberty? It is the common law, and it declares that one who interferes with another's liberty does so at his peril. This law also prescribes how arrests are to be made and the restrictions involved. Definition of false imprisonment. What constitutes a false imprisonment? False imprisonment consists of any type of unlawful restraint or interference with the personal liberty of an individual. It basically involves any unlawful violation of liberty of another. The ancient English legal scholar Henry Day Bracton, 1200 to 1268, tells us that false imprisonment is one of the oldest violations of rights known. Forcefully to deprive a man of freedom to wheresoever he may is clearly a trespass. False imprisonment was indeed one of the first trespasses recognized by the common law. False imprisonment is classified as a tort under the common law and also as a crime. It has been labeled as a tort, a trespass, an assault, a wrong, a damage, and an injury, giving one cause to bring suit against another for remedy. Depriving a person of their liberty is legally no different than depriving a person of their property. A theft of liberty is a wrong by which remedy can be had, just as is the case with the theft of a property. False imprisonment is the greatest offense due to the high regard the law has for liberty. In shitty practices of law, it states, the infraction of personal liberty has ever been regarded as one of the greatest injuries. The injuries to liberty are principally termed false imprisonment or malicious prosecution. Unlawful detention or deprivation of liberty is the basis of an action for the tort of false imprisonment. Actual seizure or the laying on of hands is not necessarily to constitute an unlawful detention. Thus, the only essential element of the action are 1, detention or restraint against one's will, and 2, the unlawfulness of such detention or restraint. In this treatise on the law of torts, Judge Cooley states, false imprisonment is a wrong akin to the wrongs of assault and battery, and consistent in imposing by force or threats an unlawful restraint upon a man's freedom of locomotion. Blackstone, in the commentaries on the law, 3 BLM Blackstone's commentary 127, states on this matter, every confinement of the person is an imprisonment, whether it be in a common prison or in a private house or in the stocks or even by forcibly detaining one in a public street. Thus, any type of detainment or confinement of a person or restriction or deprivation of their liberty or freedom of locomotion where he is compelled to remain where he does not wish to remain or to go where he does not wish to go is an imprisonment, also constitutes as kidnapping. The only question thereafter is whether or not the imprisonment is false. The word false comes from the common law and is synonymous with unlawful. A false arrest is one means of committing a false imprisonment. In describing false imprisonment as being the unlawful restraint of the liberty of the citizen or of the primary right of freedom of locomotion. The Supreme Court of Idaho also stated, imprisonment is any restraint of the personal liberty of another and prevention of his movement from place to place or his free action according to his own pleasure and will. It is false imprisonment when this is done without lawful authority. In reviewing several textbook definitions on false imprisonment, the Supreme Court of North Carolina stated false imprisonment is the unlawful total restraint of the liberty of the person. The imprisonment is false in the sense of being unlawful. The right violated by this tort is freedom of locomotion. It belongs historically to a class of rights known as simple or primary rights. The theory of law is that one interferes with the freedom of locomotion of another at his own peril. A rather complete description of what does and does not constitute false imprisonment was given by the Supreme Court of Kansas as follows. False imprisonment is necessarily a wrongful interference with the personal liberty of an individual. The wrong may be committed by words alone or by acts alone or by both, and by merely operating on the will of the individual, or by personal violence, or by both. It is not necessary that the individual be confined within a prison. Lost my place. Within a prison or within walls, or that he be assaulted or even touched. It is not necessary that there should be any injury done to the individual's person or to his character or reputation, nor is it necessary that the wrongful act be committed with malice or ill will, or even with the slightest wrongful intentions, nor is it necessary that the act be under color of any legal or judicial proceedings. All that is necessary is that the individual be restrained of his liberty without any sufficient legal cause, therefore, and by words or acts which he fears to disregard. False imprisonment exists not only by words or acts that one fears to disregard, but also by such acts and measures that he cannot disregard. No fear of disobedience need to exist. If someone causes a situation that makes it impossible for another to exercise their liberty of locomotion, it is a false imprisonment. False imprisonment is the name of the category for those torts that unlawfully deprive or interfere with the liberty of a person. Under this category, the unlawful arrest is the most common type of wrong committed. Another common way in which a wrong of this nature occurs is by the unlawful detention of a person in a room, jail, or other location. Definition for false imprisonment usually comes from unlawful restraints of this nature. False imprisonment has been well defined to be a trespass committed by one man against the person of another, by unlawfully arresting him and detaining him without any legal authority. The law sets such a high value upon liberty of the citizens that even an attempt to unlawfully arrest is esteemed a great provocation. All the authorities agree that an arrest may be made either with or without any physical force or actual touching by the officer. Thus, any illegal restraint of one's personal liberty by the act of another gives that person a cause of action for false imprisonment against the one causing the illegal restraint. Prima facie, any restraint put by fear or force is unlawful. False imprisonment is necessarily a wrongful interference with the personal liberty of an individual, usually made by an arrest, and physical custody or restraint is not essential to the effectuation of an arrest. So, if an officer tells a person that he is under arrest and he thereupon submits himself to the officer going with him and obeying his orders, such person is deprived of his liberty. And if the act of the officer is unlawful, it is false imprisonment. In all cases in which there is no physical touching or seizure nor any resistance, the intention of the parties to the transaction are to be considered. In such a case, there must have been intent on the part of one of them to arrest or restrain the other, and an intent on the part of such other to submit. Under the belief and impression that submission was necessary, the following definition will provide further insight into the nature and elements of false imprisonment. False imprisonment is the unlawful restraint by one person of the physical liberty of another, and as here used, the word false seems to be synonymous with unlawful. any exercise of force or expressed or implied threat of force by which in fact the other person is deprived of his liberty, compelled to remain where he does not wish to remain, or go where he does not wish to go, is an imprisonment. False imprisonment is the unlawful arrest or detention of a person without warrant or by an illegal warrant or a warrant illegally executed. Any restraint, however slight, upon another's liberty to come and go as he pleases constitutes an arrest. Length of time requirement. The tort or wrong of false imprisonment occurs the instance that one is restrained in the exercise of their liberty. There is no unreasonable length of time for a restraint before a tort can be claimed. False imprisonment at the common law and elsewhere consists in the unlawful detention of the person of another for any time whereby he is deprived of his personal liberty. Where two people are traveling in a car and stopped by police, and the party not driving is put in the police car and told to wait, the officer doing so is guilty of false imprisonment. Even though the person was in the police car for less than a minute, it was an arrest, as the officer had no authority for confining him in the car. Even where police officers stop a moving vehicle for a brief detention, it is sufficient to constitute an arrest. Where one is told to stay in their car by an officer, though it be for only 10 seconds, it is an arrest. Time duration is not a factor in making an arrest. False imprisonment is defined as an act which, directly or indirectly, is a legal cause of confinement of another within boundaries fixed by the actor for any time, no matter how short in duration, makes the actor liable to the other. When one is approached by an officer and questioned about his identity and actions, this is only an accosting, not an arrest. Damages and liability. One who interferes with another's liberty of locomotion does so at his own peril. All who do so without lawful authority can be sued for trespass upon liberty and loss of time. It thus is a very serious thing to deprive a person of their liberty. Since false imprisonment is a wrong suffered by a person, that person is entitled to receive a remedy for damages. Not only is a person entitled to receive a remedy for the deprivation of his liberty, but also for any other damages that are a result of that deprivation. False imprisonment was an indictable offense at the common law, and relief by the party aggrieved was obtained by an action for trespass viet etis arms, with force and arms. The illegal arrest of a person without a warrant or under an invalid warrant entitles him to compensation for damages sustained by reason of the false and unlawful imprisonment. The general rules of damages in cases of false imprisonment is that the person causing a wrongful imprisonment is liable for all the natural and probable consequences thereof. The plaintiff is entitled to recover damages for what the party wrongfully did. In Murphy versus Contis, 1 HARR period Del 143, in an action for trespass, assault, and battery, and false imprisonment, the court held that the plaintiff could recover not merely for the time and constable was bringing him to jail, but for the whole period of his imprisonment. And in Medell versus Gunsry, 51 BARB, New York, 1999, the court said that the arrest being wrongful and the defendant is liable for all the injuries consequences to the plaintiff, which resulted directly from the wrongful act. Unlawful interference with or injuries to the liberty of the citizen is a violation of this natural, inherent, and absolute right, which damages result as a legal consequence. A false imprisonment generally includes an assault and battery, and always at least a technical assault. An unlawful arrest, imprisonment, and prosecution of the person can cause that person many damages, including bodily pain, great physical inconvenience and discomfort, loss of time, mental suffering, injury to reputation, distress or anguish, humiliation of mind, shame, public ridicule, invidious publicity, and public disgrace. Some of these damages overlap so to some degree, but all can can and have been claimed in false imprisonment suits. Upon the subject of damages, the law specifies two kinds of damages or divides them into two classes. There are what are called actual damages, and then there are what are called punitive damages. Actual damages are such compensation for the injury as would follow from the nature and character of the act. They are the damages for wrongs received and injuries done when none were intended. In a false imprisonment, they could include the pain and suffering which the average citizen would be supposed to suffer under such circumstances. They further can include the physical discomfort and sense of shame, wrong, and outrage. These are also called compensatory damages, as they compensate the injured party for the actual injury sustained and no more. Punitive damages are those that grow out of the wantonness or atrocity, or aggravated by the act. They are the injuries and suffering that were intended or occurred through malice, carelessness, or negligence, amounting to a wrong so reckless and a wanton as to be without excuse. These are also called exemplary damages. Anyone who assists or participates in an unlawful arrest or imprisonment is equally liable for damages caused. Thus, where a man was illegally arrested by police officer and was placed in a patrol wagon in which he was taken to the central station, it was held that two officers in charge of the patrol wagon were liable along with the arresting officer for false imprisonment. Malicious prosecution in many cases of imprisonment or wrongful arrest. There has often been a misunderstanding made between the charges of false imprisonment and that of malicious prosecution. While both may often involve a restraint of one's liberty, the two charges are not interchangeable or synonymous. There is a fundamental difference between these two charges. They are made up of different elements, enforced by different forms of action, are governed by different rules or pleadings, evidence, and damages, and are subject to different defenses. One description of malicious prosecution is as follows. Malicious prosecution is an action ex delicito for the recovery of damages which have proximately resulted to person, property, or reputation for a previous unsuccessful civil or criminal proceeding which was prosecuted without probable cause and with malice. In an action of this type, the burden rests upon the plaintiff, the one bringing the suit, to establish each and all of the following propositions before being entitled to recover, to wit: 1. He was prosecuted in a criminal proceeding or civil suit. 2. Defendant instigated such prosecution. 3. The prosecution terminated favorable to the accused. And 4. Defendant acted without probable cause. 5. Defendant acted with malice. And 6. Damages that were caused. In Indiana, a case arose where a man sued several officers for unlawfully arresting and imprisoning him in the county jail, and without any charges preferred against him. The defendants insisted his complaint was bad as it did not allege the imprisonment was malicious and without probable cause. The state Supreme Court rejected this claim. There's a marked distinction between malicious prosecution and false imprisonment. If the imprisonment is under legal process, but the action has been commenced and carried on maliciously and without probable cause, it is malicious prosecution. If it has been extrajudicial, without legal process, it is false imprisonment. An arrest or imprisonment can be malicious or false, but not both. In a case of malicious prosecution, the arrest or detention is procured from malicious motives and without probable cause, but was done under lawful process. Whereas in false imprisonment, the detention is without proper legal authority. One may be legally arrested for some alleged reason, but done maliciously. If he is found to be not guilty, he then has a case for malicious prosecution, but not false imprisonment. If the arrest is not pursuant to legal forms of the law, then whether he is guilty or not guilty, he has a case for false imprisonment, but not malicious prosecution. If this is done with malice, it would add punitive damages to the suit. In describing the distinctions between these two charges, the Supreme Court of Oregon stated that the foundation of the cause of action for false imprisonment is the right which even a guilty man has to be protected against any unlawful restraint of his personal liberty, while a malicious prosecution case is founded upon the right of an innocent man to be compensated in damages for any injury he may sustain when a groundless charge is brought against him, even though such charge may be presented for and prosecuted in accordance with the strictest forms of law. In other words, the want of authority is an essential element in an action for false imprisonment, whereas malicious and want of probable cause are the essential in an action for malicious prosecution. Somewhat different to the wrong of a malicious prosecution is the charge of abuse of process, which is the misuse of legal process for an ulterior purpose, in which malicious or ill will may also be a factor. The term malicious arrest is used in some cases instead of malicious prosecution, but the latter is broader in scope. The law of the land. The authority to arrest without warrant was rather limited and well defined at the common law, a law which has been made part of our constitutional law in the due process provisions. The common law rule on arrest is based on the experience and common sense. As a general rule at common law, an arrest could not be made without a warrant. Thus, the right to arrest a person without a warrant is an exception to the general rule. This simple rule was expressed by Justice Carpenter in delivering an opinion for the Supreme Court of Michigan as follows. The law governing this case is elementary, except for a breach of the peace committed in his presence, or when he has a reasonable ground to believe that the person arrested is a felon or is about to commit a felony, a police officer has no authority to arrest without a warrant. The object in this law was to have a balance between preserving liberty and preserving the peace. Those who committed the most heinous crimes, that being felonies, were a threat to the safety of society and could be summarily deprived of their liberty by arrest. Those committing a breach of the peace could also be summarily arrested, not for apprehension as a criminal, but to preserve the peace. But for other offenses, summary arrests had to yield to the liberty of the citizens. The liberty of the citizens is too sacred to be left to the arbitrary will of men. Everyone knows that what felonies are. The most common felonies are murder, rape, kidnapping, sodomy, armed robbery, abortion, pedophilia, treason, and arson. A breach of the peace is also obvious and well known. Therefore, everyone's liberty was safe, since all knew for what reasons they could or could not be arrested. But where is the safety in one's liberty if they are to be subject to every ordinance or law that legislative bodies may choose to enact, or if the law on arrest can be changed by statutes? By the Due Process Clause, the common law governs that what the law on arrest is in this land, and where it exists, the most statutes can be is declaratory of the common law. If there is no direct language in the Constitution directing what procedure or process is to be followed, the common law is to be the due process of law followed, not a legislative, statutory, or city ordinance. Officers who do not abide by the law are trespassers and are guilty of false imprisonment. The following is some material to help the citizen in protecting his liberty from unlawful encroachment by executive officers. First, to initiate a suit against one who unlawfully deprives you of your liberty, there is an example of a summons and a complaint which need to be served upon the defendant and the court. There is also a memorandum of law on the subject of arrest without warrant, which is legal proof of the law that has existed for hundreds of years on this matter. State of Minnesota, County of New Hampshire, Charles A. Wiseman, plaintiff versus Mark L. Franken, defendant, 4th Judicial District, District Court, summons To defendant above named, you are hereby summoned and required to serve upon the plaintiff an answer to the complaint, which is herewith served upon you within 20 days after service of the summons upon you, exclusive of the day of such service. If you fail to do so, judgment by default will be taken against you for the relief requested in the complaint. Dated August 23rd, 1993. Charles A. Wiseman, plaintiff. I'm not going to say his address, all right? Plaintiff for this complaint against defendant states and alleges. On September 30th, 1992, plaintiff was traveling in his automobile on a public highway called I-35 West between Richfield and Minneapolis, going northbound, when stopped by the defendant, acting as a highway patrolman, so important, and employee of the state of Minnesota. The defendant asked plaintiff to see his driver's license. The plaintiff explained that he is not a licensee under any board of or commission and is not required to be a licensee. The defendant insisted that the plaintiff must have said license. The defendant then arrested, searched, and handcuffed the plaintiff without warrant, and over his objection, the defendant's acts were in violation of plaintiff's rights and the constitutional provisions of due process of law. The defendant gave no specific charges to the plaintiff for his being stopped or for the arrest, nor did he advise him of his rights as shown in the defendant's filed report, which contained only traffic misdemeanor charges. A copy of this report and an official complaint was received by plaintiff 2 months after the arrest. The defendant brought the plaintiff to the Hennepin County Jail, where the defendant knew that the plaintiff would be subject to booking, which included fingerprints, photographing, and confinement for an indefinite period of time, and possibly be subject to other types of assault and batteries. Further, the plaintiff, by his own admission, made no attempt to bring the defendant before a magistrate or judge when he had full opportunity to do so, being that the arrest occurred at 10:15 a.m. on a Wednesday. The defendant, acting on his own accord and without warrant or court order, had the plaintiff's automobile towed to an impound lot and put it on hold order. Okay? It's very important that we take cognizance of the fact that they're acknowledging the fact that the officer, the man, did not take him to the magistrate. They're supposed to take you directly to the magistrate without hesitation. The nearest magistrate, I don't give a fuck if it's 3 hours away in bumfuck Egypt. They've got a duty to take you there. Okay? False imprisonment. Plaintiff realleges paragraph 1 through 7 on September 30th, 1992. The defendant with the warrant, without warrant or due process of law, Minnesota Constitution, Article 1, Section 7, unlawfully arrested the plaintiff and, acting contrary to law, did falsely imprison the plaintiff, depriving him of his liberty. As a result, the defendant's false imprisonment of the plaintiff had his rights to liberty violated, suffered mental anguish, a loss of time and wages in his work, and a discredit in his reputation by his failure to attend a scheduled meeting. Count 2, false imprisonment. Plaintiff realleges paragraphs 1 through 7. The defendant, upon arresting plaintiff, brought him to the county jail for the purpose of booking and detaining him, and by his own admission made no attempt to bring the plaintiff before a proper judge or court as is required by due process of law, a proper court having proper jurisdiction. The acts of the defendant is in deciding how to deal with the plaintiff after his arrest and failing to take him to the judge or court to so decide constitutes false imprisonment by the defendant under the law of the land, Minnesota Constitution, Article 1, Section 2. This man's clearly a state national owing an allegiance to his state, protected by the Constitution of said state. Okay. Count 3, assault and battery. Plaintiff realleges paragraphs 1 through 7. Due to the unlawful acts of the defendant, the plaintiff suffered a series of assaults and batteries upon his person, including arrest, handcuffing, imprisonment, physically searched, forced fingerprints, and booking procedures and harassment. Therefore, plaintiff demands judgment against defendant as his liability appears in the sum of $10,000 together with the cost of disbursements, dated June 24th, 1993. State of Minnesota comes now the plaintiff, Charles A. Wiseman, a free citizen of the state of Minnesota, who respectfully presents and submits this memorandum as evidence and proof of the prevailing and controlling law regarding the matter now before the court. Arguments and statements of law. The defendant claims that his arrest of the plaintiff without warrant for the violation of 2 traffic laws was lawful. Defendant claims that he is authorized by statute to make arrest for any violation of law of the state, whether they are a misdemeanor or a felony, when committed in his presence. Now, remember, this is why I've been talking to you guys for the last couple days about status. When this officer is saying statute provides, he's presuming and assuming that this man is part of the federal enclave, statutory citizen, and statutorily bound by civil statutory law that is created by the legislator and the Congress. Okay, this is the fallible, palpable error that agents and agency make and are 100% liable for, because they're never taught this when they're going through the police academy training. They're never taught that men that have a certain status, that know who they are, that are a member of the Union States, protected by the Confederation of the Union of States, that have an allegiance to the state, are state nationals and are not subject to civil statutory rules and procedures and private policy. Okay, so this is where this guy is going to prevail, because the defendant is exclaiming and alleging that, oh, Your Honor, this guy he's under our federal control. He's within the territories and federal enclaves, and we absolutely have jurisdiction to do this. It is in fact my duty to do this and accost this man and throw him into a fucking cage for a frivolous claim for which cannot be defended under the guise that somehow the statutes applied to him. Well, under Federal Rules of Civil Procedure 17B, we clearly see that Federal Rules of Civil Procedure is a civil statutory law. The DMV rules, regulations, and all that gooply gawk shit only applies to people who fill office or are officers. Okay, period. End of fucking story. So this cop was way off his rocker, and he's going to lose 10 G's out of the deal. The thing is, the county's not going to pay it. The state's not going to pay it. Oh, no. It's going to come directly out of this officer's pocket, because the second that he violated this man's rights, the insurance policy that they're under, whether it be the criminal policy, the fidelity good faith bond they have, whether it be the blanket bond they have, when you read the actual insurance provisions, it says and reads, if you act arbitrarily outside of your delegated authority in breach of this contract, we are not liable for covering the damages that you may sustain in a personal lawsuit. Okay, so they're going to walk away from this officer. This officer is now going to foot the bill at 10 fucking G's because he wasn't properly trained. Okay, he wasn't adequately provided the right information. So it's really unfair to the officers too. The government's taking full advantage of them as well. The lawyers are giving them this false sense of security that they can do all this shit and they'll be all right. But when push comes to shove and somebody really knows what the fuck they're doing, I'm telling you right now, that the district attorney, the prosecuting attorney will walk away from them quicker than shit and say, you're on your own, you're going to have to hire a private attorney. We can't help you. Unfortunately, you're not covered underneath our policy. It says right here in our insurance policy that if you breach your duty, you breach the oath that you took, you don't act in good faith, you're acting in bad faith, you are now 100% personally liable for this. Sorry about your luck, Scooter, but you're going to get taken to the cleaner by this guy because he happens to know the law. He happens to realize that he is not a statutory citizen. He is not an officer filling an office, and they can't bring suit against him, throw him in a cage maliciously. It's a wanton disregard for law, okay? Carrying on. Statute to make an arrest for any violation of the law of the state, whether they are a misdemeanor or a felony when committed in his presence. The fact of this case lead to the conclusion of law that the defendant did not have any lawful authority to arrest the plaintiff. Uh-oh, he's in trouble. the defendant had no warrant for their arrest of the plaintiff, meaning that there was no grand jury indictment, there was no APB put out on him, there was no warrant signed by the judge, supported by oath and affirmation with an attached affidavit to it, okay? And he alleges that that he only saw a plaintiff commit a misdemeanor, i.e. a traffic violation. Traffic violation, ladies and gentlemen, is not a violation of the law. It's a violation of the DMV code. And most agents and agencies operating as state troopers, sheriff's department, and police officers are not authorized to enforce the motor vehicle code. Okay, that's the job of the DOT. There was no claim of a felony committed or of a breach of peace committed. At common law and under the provisions of due process of law, such an arrest without a warrant cannot be made. Since the arrest deprived the plaintiff of his liberty by an act of not pursuant to due process of law, notice an opportunity, the arrest is unlawful. Due process is not determined by the legislator. It is manifest, it was not left to the legislative power to exact any process which might be devised. The due process article is a restraint on the legislative as well as on the executive judicial powers of government, and cannot be so construed as to leave Congress free to make any due process of law by its mere will. Murphy's Lisi versus Cabocan in IMP.co, 18 HOW 59 US 272-276. This case was supported in 1855. The Constitution of Minnesota declares that no person shall be deprived of life, liberty, or the pursuit of or of property without due process of law. Minnesota Constitution, Article 1, Section 7. Now, in all 50 states, they all have a constitution, and they all read similar, if not the same, verbatim, okay? The words due process do not mean anything which the legislator may see fit to declare to be due process of law. State ex rel versus Billings, 55, Minnesota, 466, Minnesota, 466, 474, 1893. Due process was extended to preserve established fundamental rights by requiring that they cannot be deprived except by the established modes of law as existing under the common law. This guaranteed the government shall follow as specified and pre-existing rule of conduct, process, or procedure, modes, is in itself a right the citizen held at common law and was claimed by the colonist in early America. Thus it is clear that the common law is the foundation of that which is designated as due process of law. 6 RCL Constitutional Law, subsection 435. The Constitution guarantees these pre-existing rights and procedures in the due process provisions. What is due process of law may be ascertained by an examination of those settled usages and modes of proceedings existing in the common and statute law of England before the immigration of our ancestors. Twing versus New Jersey, 211 U.S. 78 100, 1908. The expression due process of law and law of the land have the same meaning. The law intended by the Constitution is the common law that had come down to us from our forefathers, as it existed and was understood and administered when that instrument was framed and adopted. State versus Doherty, 60 Maine, 504, 509, 1872. In interpreting what due process of law is, it has been held that none of our liberties are to be taken away except in accordance with established principles. Elkern versus McGovernor, 154, Wisconsin, 157, 142, N period, W period, 595, 620, 1913. Thus, the mode of arrest by which one can be deprived of his liberty is to be detained by the pre-existing common law principle and mode of procedure. A properly constituted warrant of arrest is a process at the common law by which persons could lawfully be deprived of their liberty. The common law on arrest without warrant recognized only certain specific and well-defined cases whereby a citizen could be deprived of his liberty. This cannot be abrogated or changed by the legislator. The common law drew a distinction between an arrest for misdemeanors such as that which the defendant arrested the plaintiff upon, and arrest for felonies. When a felony was committed, an arrest could be made without a warrant, but no arrest could be made for a misdemeanor without a warrant unless it continued a breach of the peace. The misdemeanor traffic violation was not a breach of the peace, and thus the defendant needed a warrant to make an arrest for such offense. In determining the law surrounding arrests, the Supreme Court of South Carolina, in the case of State v. Byrd, BYRD, 72 S.C. 104 51 S.E. 542, 544, 1905, affirmed a prior decision of the court holding that, at the common law, as a general rule, an arrest could not be made without warrant for an arrest less than a felony, except for a breach of the peace. 3 CYC 880, State v. Sims, 16 S.C. 486. The fact that the defendant believed that the plaintiff committed a misdemeanor and had charged him with a violation of a traffic law did not authorize him to arrest the plaintiff. In the New York case, the state Supreme Court held that a city alderman or justice of the peace could not, at common law, arrest or cause an arrest for a misdemeanor not amounting to a breach of the peace without a warrant, though happening in his presence. The Supreme Court, in the case of Boltoff versus Blust 5 Lansing, REP 8486 1871, stated, at the common law, an arrest could not be made of a person charged with a misdemeanor except on warrant of a magistrate, unless it involved a breach of the peace, in which case the offender might be arrested by any person present at its commission. First Chitty Criminal Law 15, Carpenter versus Mills, 29 HOW PR period R period 473. In the very well-reasoned and authoritative case of Ex Parte Rhodes, 202 Alabama, 6879 SO period 462, 464, 1918, the Supreme Court held of Alabama related the due process provisions to the act of arrest. It asserted that any seizure or arrest of a citizen is not reasonable or due process merely because the legislator has attempted to authorize it. These phrases are limitations upon the power of the legislator, as well as upon that of the other department of government or their officers. In determining what was due process regarding arrest, the court stated, it must not be forgotten that there can be no arrest without due process of law. An arrest without a warrant has never been lawful, except in those cases where the public security requires it. And this has only been recognized in felony and in breaches of the peace committed in the presence of the officer, which means he physically has to fucking see it. Ex Parte Rhodes, 202 Alabama, 6879 SO 462, 465, citing Sarah Way's case, 41 Michigan, 304, 1 N period W period 1023. This case was had in 1879, and E.T. also cited and affirmed in Pinkerton versus Verbiage, 78 Michigan, 573, 44 N period W period 579, 583, 1889. State versus Williams, 45 Oregon, 314, 77 Pack, 965, 969, 1904, and Adair versus Williams, 24 Arizona, 422, 210 Pack, 853, 856, and the case was supported in 1922. The Alabama Supreme Court in Rhodes' case went on to say that the phrase due process must be determined by what it means at the common law, and when the Constitution was adopted, page 469, the court then cites the case in Tillman versus Beard, 121 Michigan, 475, 80 N period W period 248, 1899, in stating, officers are justified in arresting without warrant only in cases of felony and breaches of the peace. This is elementary. It is needless to cite authorities. At one time in history of American law and jurisprudence, the concept that no one could be arrested for a misdemeanor except with a proper warrant was so basic and elementary that it was not necessary to give any authorities to prove it. Yet this basic concept was found to be too restrictive to the ever-growing oppressive government that has gained power in this country. Thus, in order to control the liberty of citizens and to enforce its oppressive laws, taxation without representation, the corrupt de facto government has gradually undermined a very basic principle of constitutional law. In the Pinkerton case, Supra, it was held that the police officer could not arrest a woman without a warrant upon mere suspicion that she was upon the streets for the purpose of prostitution. Even under provisions of the city ordinance allowing such arrest, the fact that she had a reputation of being a streetwalker and that the officer knew of her reputation and believed she was plying her vocation as such, plus the fact she did not give her name to the officer, stating it was none of his business, and that she dared the officer to arrest her, did not give the officer grounds to arrest her. The court said, if persons can be restrained of their liberty and assaulted and imprisoned under such circumstances without complaint or warrant, then there is no limit to the power of a police officer. Any law which would place the keeping and safe conduct of another in the hands of even a conservator of the peace, unless for some breach of the peace committed in his presence or upon suspicion of a felony, would be most oppressive and unjust, and destroy all the rights which our Constitution guarantees. These are rights which existed long before our Constitution, and we have taken just pride in their maintenance, making them a part of the fundamental law of the land. Pinkerton versus Verbiage, 78 Michigan, 573, 44 in period, W period, 579, 582, 83, 1889. Larson's versus Fenney, 196 Michigan, 162 in period, W period, 275, 276 hyphen 77 in 1917. Under the topic of arrest, as found in volume 2 of the ruling case law. And remember, there is no case law, it's case precedent, it isn't case law. The judiciary doesn't have the power to create law, okay? That's a misnomer and an egregious misconception. It's a false conveyance of language, okay? We find the heading constitutional requirements as to warrants here, wherein it states, the fundamental constitutional guarantees of personal liberty protect private individuals in the right of enjoyment of personal freedom without unlawful restraint, and it is universally recognized that no one may be arrested except by due process of law. 2 RCL 463, subsection 21. Herein again we find that the principle of arrest only by due process of law was once universally recognized, yet the defendant has ignored such process in his arrest of the plaintiff. The law regarding warrantless arrest was also declared by the Supreme Court of Wisconsin in the case of Radloff versus National Food Store, Inc., 20, Wisconsin, 2D, 224, 121, in period, W period, 2D, 865, 867. This case was had and supported in 1963 as follows. In Stidingen versus Rundle, 1898, 99, Wisconsin, 78, 80, 74, in period, W period, 563, this court established the principle that an arrest without a warrant has never been lawful except in those cases where the public security requires it. And this has only been recognized in felony and in breaches of the peace committed in the presence of the officer, which means he has to be able to testify with first-hand, perfected, superior fucking knowledge, all right? He can't rely on hearsay from somebody that's called them to the scene saying this guy's disturbing the peace. He must physically see it himself. Okay, this rule was reaffirmed in Gunderson versus Stubing, 1905, 125, Wisconsin, 173, 104, N period, W period, 149, First American Law Reports, annotated 585. The Radloff case involved a shoplifter who was stopped and arrested by store employees for taking 2 cartons of cigarettes. The state Supreme Court said that the employees had the right to stop the shoplifter and recover the goods he had stolen from their employer and were not negligent per se in doing so. However, since the taking of the cigarettes constituted a misdemeanor, the store employees had no right to arrest the shoplifter when they had no warrant to arrest. In the Gunderson case, the court explained that the arrest without warrants were allowed at the common law only where the ends of justice would be defeated without it, and that it must be confined to case of strict public necessity. where a person was arrested without warrant and charged with public drunkenness, which resulted in a charge of resisting arrest, it was held by the Supreme Court of North Carolina that the arrest was illegal as the state failed to make a prima facie case by showing that the defendant's conduct at the time of arrest amounted to either an actual or threatened breach of the peace. The court said it is manifest that mere drunkenness unaccompanied by language or conduct which creates public disorder amounting to a breach of the peace will not justify arrest without warrant, and that not every misdemeanor is a breach of the peace. In a very well-reasoned decision on the subject of arrest, the court held the following. It has always been the general rule of the common law that ordinarily an arrest should not be made without warrant, and that subject to well-defined exceptions, an arrest without a warrant is deemed unlawful. Fourth Blackstone's Commentary, 289 ETSEQ. 6 Corpus Juris Secundum Arrest, subsection 5, page 579. This foundation principle of the common law, designed and intended to protect the people against the abuse of arbitrary arrest, is of ancient origin. It derives from assurance of the Magna Carta and harmonizes with the spirit of our constitutional precepts that the people should be secure in their persons. Nevertheless, to this general rule that no man should be taken into custody of the law without the sanctions of a warrant or other judicial authority, the process of the early English common law in defense to the requirements of public security worked out a number of exceptions. These exceptions related in the main case involving felonies and suspected felonies and to the breach of the peace. Authority cited: State versus Mobley, 240 N period C period 476 83 S period E period 2D 100 102. This case was had in 1954. The overall opinion of the court stressed the principle of the common law as controlling an arrest, thus characterizing as erroneous the view that any offense in the presence of an officer is arrestable without a warrant. In Texas, it was held that an arrest without a warrant for selling in the officer's presence a railroad ticket in violation of the city ordinance prohibiting the selling of such tickets was unlawful, as an offense charged was not a felony nor an offense against the public peace. MK and T period RY period Co period versus Warner, 19 Texas Civil Appellate Level 463. This case was had in 1898. Sheriff constables and other officers under the executive branch of the government had always been recognized as having the authority to arrest for felonies committed and for misdemeanors amounting to the breach of the peace. But this is the extension of their power to arrest without a warrant, and this constitutional principle is well grounded in the ancient common law safeguards of individual liberty. In England, under the common law, sheriffs, justices of the peace, coroners, constables, and watchmen were entrusted with special powers as conservators of the peace, with authority to arrest felons and persons reasonably suspected of being felons. Conservators of the peace also had the authority to make arrests without warrants in cases of misdemeanors which involved a breach of the peace committed in the presence of the officer making the arrest. 2 Ruling Case Law, P. 466, and again, there's no fucking case law. I absolutely hate seeing that shit. There's no such thing as case law. It's case fucking precedent, okay? Stare decisis, well-established, well-defined rulings and decisions, which are really mere opinions, but subsequently happen to be in favor of the law of the land, and constitutionally speaking are accurate assessments from my purview anyway. Org versus the State, 105 SO period 465 469 Mississippi 1925, and Grom versus State, 143 GA 440 85 S period E period 328 330 1915, and Kennedy versus State, 139 Mississippi 579 104 449 and 450, 1925. Wilson versus Town of Mooresville, 222 N period C period 283 22 S period W period 2D 907 911. Case was had in 1942. And People versus McGurn, 341 triple 632 173 N period E period 754 756 1930. It has been been held that constitutional provisions of rights are to be interpreted according to the common law statutes common and statute law of England prior to the emigration of our ancestors, and by the law established here before the Constitution was adopted. Under the common law, the powers of state agents were limited to the requirements for an arrest warrant was strictly enforced. United States versus Tarlowski, guessing he's a Polak because it ends with a ski. 305 F period SUPP period 112-116 1969 was when this case was upheld. This procedure for arrest, in part of the due process of law provision of the Constitution, which protects citizens from the arbitrary infringement of their rights to personal liberty. Thus, any specific authority for arrest must be based upon the common law procedures that allowed a deprivation of one's liberty. This was so held by the Supreme Court of Michigan as follows. It has already been decided that no arrest can be lawfully made without warrant, except in the cases existing at the common law before our Constitution was adopted. People versus Swift, 59 Michigan, 529, 26 N period, W period, 694, 698, 1868. Since liberty cannot be deprived except by law of the land or due process of law, no statute or ordinance can constitutionally be enacted which allows arrest without a warrant for any purpose the legislator decides. Due process is a limitation upon the legislator, and thus a legislative statute cannot be the due process by which one can be deprived of his liberty by arrest. In a legal article titled Arrest with and Without a Warrant, written in the University of Pennsylvania Law Review, Volume 75, Number 6, April 1927, page 485, numerous authorities were cited in support of the following proposition. It is usually said that not even a peace officer is privileged to make an arrest without a warrant for a misdemeanor which does not amount to a breach of the peace, and there are many cases which expressly deny the privilege to arrest for such a misdemeanor, page 486. In the annotation of the American Law Reports, Volume 1, page 584, is found a legal study titled Constitutionality of Statute or Ordinance Authorizing an Arrest Without a Warrant, in which the following is stated. It has been stated that in cases less than a felony, an arrest could only be made without warrant where there was a breach of the peace in the presence of the person arresting. Case cited. The limits to the power of arrest by constable without process was well defined at the common law. To prevent the escape of a felon, he had authority to arrest anyone whom he reasonably suspected to have been engaged in the perpetration of a felony. To prevent breaches of the peace, he had the right to arrest any person who was engaged in or in his presence threatened to engage in any affray, or other breach of the peace. Beyond this, the law did not allow him to exercise the function of determining whether there was a sufficient case of the violation of law to justify an arrest. Read J in Newark in EWARK versus Murphy, 1878-40 in period J period L period 145. After this excerpt, the law report stated that the foregoing statement for Newark versus Murphy is in accordance with the weight of American opinion. Those cases which seem to deviate from the proposition are those which have upheld arrest for certain acts that were unlawful at the common law, such as streetwalkers. The Tideman's treatise on the limitations of police power, 1886, subsection 33, found that the requirements of the law for a lawful arrest and the exceptions to a warrantless arrest. 33. What constitutes a lawful arrest? As a general proposition, no one can make a lawful arrest for a crime except an officer who has a warrant issued by a court or a magistrate having the competent authority. 33A, arrest without a warrant. Although it is the general rule of the law that there can be no arrest without a warrant of the nature just described, yet there are cases in which the requirement of a warrant would so obstruct the effectual enforcement of the laws that the ends of the justice of justice would be defeated. For public reasons, therefore, in a few cases, the personal security of the citizens is subject to the further liability of being arrested by police officers or private individuals without warrant, but the right thus to arrest without a warrant must be confined to the case of strict public necessity. The cases are few in number and may be stated as follows. When a felony is being committed, an arrest may be made without warrant to prevent any further violation of the law. When the felony has been committed and the officer or private individual is justified by the facts within his knowledge in believing that the person arrested has committed the crime. All breaches of the peace in assault and batteries, affrays, riots, etc., for the purposes of restoring order immediately. The rules of the common law that a peace officer or a private citizen may arrest a felon without a warrant or on view a breach of the peace has never been extended to any and all misdemeanors. While there have been some erroneous decisions that have recognized statutes authorizing arrest for misdemeanors that do not constitute a breach of the peace, none are based upon the meaning of due process of law. Thus, arrests are not lawful where only a misdemeanor occurs unless it is of the nature of a breach of the peace. At the common law, an officer had no authority to make an arrest for a misdemeanor, though committed in the presence, unless it involved a breach of the peace. The right of the personal liberty is a very high prerogative right, and to deprive one of that right without due process of law, we must find specific authority for doing so. It cannot be left to interference or some strained construction of statute or ordinance. State versus Lutz, 85W period VA period 330 101 S period E period 434 43 1919. We come back, we'll delve deeper into this, and we'll get it into more of false arrest and false imprisonment to help you guys out. We've been talking about status and status correction. Now I want to shift your mind over to the cause of action you have when you realize that you are not statutorily bound to the whims of the legislator, okay? Remember, government was instituted amongst men to protect our property, and our rights are property, and they're firmly cemented into every state constitution, the Confederacy of the Union of States, and then again supported again when the Union of States entered into a compact with the United States of America and the United States, okay? So it's really important to know your status, know who you are, know that you're not an officer, know that you're not subject to the Congress or the legislative branch, all right? Statutorily speaking, you're not. Unless you're engaged in murder, theft, rape, it doesn't apply to you, period. End of story. So the confusion comes in with the status where they presume and assume you to be an officer or filling an office, and then you are bound by the statutes, codes, city ordinances, rules, and regulations and provisions that they created for themselves. Remember, when policy, private policy, acting as private law or public law, as far as it's concerned, you must be a party to that organization. And you can make the decision whether or not you're a U.S. citizen or not. That is completely up to you. But don't cry to people like me when you're getting hemmed up because all of the documentation that you've ever submitted to the government leads them to believe with prima facie evidence that you've been duly informed and you made a conscious, knowingly, willingly, and intentionally decision to join the ranks of the United States as a volunteer United States citizen, and thus waiving all your rights and gaining a shit ton of bogus privileges, okay? And that's the facts. When we come back, we'll get more into this.